Welcome to the Principles of the Constitution podcast. This podcast is different from the Principles of Government one because these principles are specific to the U.S. Constitution. They have less to do with the reasons governments exist and more to do with the values our government holds. While most democracies hold similar underlying values, no democracy functions exactly the same. The founders constructed the Constitution very purposefully. They laid these principles down in the very fabric of how our government is organized and the way in which we hold elected officials accountable. Whether stated or implied, these principles are just as important today as they were at the Constitutional Convention. They are the tools we need to think about when interpreting the intent of the Constitution. Before I start discussing the principles, I would like to give a brief overview of the Constitution and what it is and is not. The Constitution is the framework for government. It's an outline. It doesn't contain laws, but rather contains the framework for making laws. It establishes the branches and their roles, as well as the relationship between the states and federal government. Due to its broad nature, it also allows for the people to establish specific roles and systems for governing over time as needed. It does this all in 7 fairly succinct chunks called articles. The 7 articles of the Constitution are the body of the Constitution. They are the meat, especially Articles 1 through 3 on the 3 branches, which will be discussed in 3 Branches podcasts. The other articles are also important, as they establish the relationships among states and between states and the federal government, ways to amend or change the Constitution, and how to ratify or approve it. These will be touched upon more in depth at various times. As we learned in a previous podcast, the preamble is the introduction for what is to come, stating the goals the founders hoped to achieve in writing this document. After the articles come the amendments, which are the Bill of Rights and later changes to the Constitution. When thinking about the Constitution as a document and how the underlying principles are weaved into this document, it is important to know that the Constitution didn't go into effect until after the Bill of Rights, the first 10 amendments, were added. We can thus see how the principles of the Constitution are not only relied upon in the articles, but in the preamble and amendments as well. Now that you have a general overview of what the Constitution is and what it contains, I'm going to discuss the basic principles on which it was based. There is no set correct number of principles. Sometimes some may be combined and other times left out. For our purposes, we will be looking at these 8 principles. These principles are popular sovereignty, consent of the governed, limited government, rule of law, separation of powers, checks and balances, judicial review, and federalism. Each will be discussed separately. We'll begin with popular sovereignty. The concept of popular sovereignty is that the power is derived from the people. This is such a fundamental idea that the Constitution begins with "we the people." The idea that people are the source of power is in opposition to other forms of government, such as monarchies, where the power lay with a leader who is not representative of the people. In the U.S., the people created the government and the people are the ones who sustain it. Going hand in hand with popular sovereignty is consent of the governed. It is impossible for the power to start with the people if the people don't have a choice over who governs them. In fact, the United States is a republic, meaning that the people in charge are elected. There is no unelected king, queen, or religious leader. The people instead have a say in who gets power. If leaders don't have the approval or consent of the people, they will use elections to vote them out of office. Following those 2 is limited government. The Constitution starts with the idea that the government isn't all-powerful. It defines what the government can't do to the people. For example, people have inalienable rights, such as the freedom of speech and religion, that the government can't take away. Also, the federal government has powers only specifically given to it, with other powers being left to the states. Therefore, the U.S. government is limited by the rights both individuals and states have. The way the government is set up not only limits what it can do, but also limits the powers of those in charge. This is called rule of law. Society is governed by laws that everyone must follow. No person is above the law, and everyone must act in accordance with it. This means that elected officials must act in a way that shows they are preserving, protecting, and defending the Constitution. All government officials can be prosecuted for crimes and or be removed from office. This is one way that officials can be held accountable and not gain too much power. In fact, the founders wanted to make sure that power was not concentrated in one part of the government. They made sure there was a separation of powers. They were concerned with one person or a group of people holding too much power. Therefore, they created 3 separate branches with 3 different roles. The 3 branches are the legislative branch that makes the laws, the executive branch that carries out and enforces the laws, and the judicial branch that interprets them. The idea was that power would be split between the 3 so that no one branch was all important. Even with the 3 branches of government, the founders were concerned that one branch could overpower the others. Therefore, they included the concept of checks and balances. This allows for one branch to curb the power of the other. For example, the Constitution makes sure that more than one branch approves laws and treaties before they go into effect. Another example is that the legislative branch can remove the president or other elected officials from power if they commit high crimes and misdemeanors. Not only is power split between 3 branches that can check and balance each other, but power is split between the states and the federal government. This is called federalism. While the federal government is the supreme law of the land according to Article 6 of the Constitution, the federal government only has powers that it is given. Granted, these powers have been broadly interpreted over time, but individual states still have a significant say in how they govern. For example, it is the states, not the federal government, who make laws regarding education and punishments for most crimes. Lastly, there's the concept of judicial review. The judicial branch has the power to hear certain types of cases, and the courts have the authority to decide whether or not something violates the Constitution. While this concept was not clarified in the Constitution, the Supreme Court ruled less than 15 years after the Constitution went into effect that federal courts did indeed have the power to declare something unconstitutional. We view this as a basic principle because it allows the Constitution to be interpreted. Judicial review makes sure that even though issues arise and new laws must be passed, leaders are always doing so in accordance with the Constitution. The founders didn't leave us with a document meant to work in one way at one specific point in time, but instead left us with a document that had the tools to withstand the passage of time and meet the needs of an ever-changing society. They ensured this due to preserving these principles in the structure and function of the Constitution. Thanks for listening.